before you double check the cameras too.
I checked mine.
They look good on the monitor on Zoom.
He said they look good on the monitor.
It's live now. All rise.
Please be seated. Good night. Just so you know, it's going to be live streamed on YouTube. If I found out I had a channel. But it's going to be streamed, but you will not be on it. We had a crew out Lansing from the State Board Administrator's Office come down. They helped us out, making sure that we got everything handled. There won't be any video of you in there. As a matter of fact, it cuts right across the edge of here. And you won't get picked up over that way. Okay. Okay. Now I'm going to go through some basic instructions. Ladies and gentlemen, as you know, I'm Judge Wilson. It's my pleasure and privilege. Whoops, hold on. Okay. Ladies and gentlemen, the jury, you've been chosen to decide a criminal charges made by the state of Michigan against your fellow citizens. We've already sworn them in, so we're going to be good there. Don't worry about that. I'm going to go through some legal principles that apply to this case. First, the prosecutor will make their opening statement and give their theories about the case. The defendant's lawyer does not have to make an opening statement. Defendant's lawyers do not have to make an opening statement, but they may make an opening statement after the prosecutor makes theirs, or they may wait until later. These statements are not evidence. They're only meant to help you understand how each side views the case. Next, the prosecutor presents their evidence. The prosecutor may call witnesses to testify. They show you exhibits like documents or objects. The defendant's lawyers have a right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of their evidence, the defendant's attorneys may also offer evidence, but do not have to. By law, the defendants do not have to prove their guilt or their innocence. I'm sorry. Do not have to prove their innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has a right to cross-examine them. Prosecutor may also call witnesses to contradict the testimony of the defense witnesses. After all the evidence has been presented, the prosecutor and defendant's lawyers will make their closing arguments. Like opening statements, these are not evidence. They're only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. Now, my responsibility as the judge in this trial are to make sure the trial is run fairly and efficiently, to make decisions about the evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses says. What you decide about any fact in this case is final. When it is time for you to decide the case, you're only allowed to consider the evidence that was admitted in the case. Evidence includes only the sworn testimony of the witnesses, the exhibits admitted into evidence, and anything else I may tell you to consider as evidence. It is your job to decide what the facts of the case are. You must decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a witness's testimony, you must set aside any bias or prejudice you have based on race, gender, or national origin of the witness. There's no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Now, the questions the lawyers ask the witnesses are not evidence. Only the answers are evidence. You should not think something is true just because one of the lawyers asks questions that assumes or suggests that it is. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinions about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, the lawyers may object to certain questions or statements made by the other lawyers or witnesses. I'll rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of this case. Sometimes the lawyers and I will have to discuss matters out of your hearing. Also, while you're in the jury room, I may have to take care of other matters that have nothing to do with this case. Please pay no attention to these interruptions. Now, you must not discuss this case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I'll send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. When the trial is over, you may, if you wish, discuss this case with anyone. If I call for a recess during trial, I'll either send you back to the jury room or allow you to leave the courtroom on your own and go about your business. But you must not discuss the case with anyone or let anyone discuss it with you or in your presence. If someone tries to do that, tell him or her to stop and explain that as a juror, you're not allowed to discuss the case. If he or she continues, leave and report the incident to me as soon as you return to court. You must not talk to the defendants, the lawyers, or the witnesses about anything at all, even if it has nothing to do with the case. It is very important that you only get information about the case while you are in court and when you are acting as a jury and when the defendant, the lawyers, and I are all present. So if you get on the elevator and any of the attorneys or any of their staff ignore you or don't respond to you, it's not that they're trying to be rude. It's just that they dealt with this many times and they know that they're not allowed to speak with you. Now, during the trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they could give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow the instructions. The only information you will receive about this case will come to you in the courtroom. You must not consider any information that comes from you anywhere else. Must not read newspaper headlines or articles relating to the trial. Also, you must not watch or listen to television or radio comments or accounts of the trial while it's in progress. Until your jury service is concluded, You are not to discuss the case with others, including other jurors, except as otherwise authorized by the court. You are not to read or listen to any news reports about the case. You may also not use a computer, cellular phone, or other electronic device with communication capabilities while in attendance at trial or during deliberations. These devices may be used during breaks, recesses, but may not be used at any time to obtain or disclose information about a party, witness, attorney, or court officer. News accounts of the case or information collected through juror research on any topics raised or testimony offered by any witness or by any exhibit. Now, you must not visit the scene of any occurrences that may be subject of this trial. If it should become necessary for you to view a scene, you will be taken as a group under court supervision. You must not consider as evidence any personal knowledge you have of the scenes. You must not do any investigations on your own or conduct any experiments of any kind. This includes using the internet for any purpose regarding this case. If you discover a juror has violated my instructions, you should report it to me. You may take notes during the trial if you wish, but of course you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except the other jurors see them. You must turn them over to the bailiff during recess. Now, as you can see, we've got 15 jurors here. After you've heard all the evidence and my instructions, we will draw lots to decide which of you will be dismissed to form a jury of 12 persons. So put all the numbers and names in a thing and just draw them out. Possible penalty should not influence your decision. It is the duty of the judge to fix the penalty within the limits provided by the law. I may give you more instructions during the trial, and you should consider all of my instructions as a connected series taken all together. They are the law you must follow. After all the evidence has been presented and the lawyers have given their arguments, I will give you detailed instructions about the rules of law that apply to this case. Then you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decisions of each juror. It is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. Okay. Now, ever give me that other information so that all three are the same?
I haven't yet, Judge.
Okay, could you bring that tomorrow?
I will.
Okay. In a moment, I'm going to instruct you on the law. I'll explain the laws that apply to this case. Remember, you have taken an oath to return a true and just verdict based only on the evidence in my instructions on the law. You must not let sympathy or prejudice influence your decision. As jurors, you must decide what the facts of the case are. This is your job and nobody else's. You must think about all the evidence and then decide what each piece of evidence means and how important you think it is. This includes whether you believe what each of the witnesses said. What you decide about any fact in this case is final. It's my duty to instruct you on the law. You must take the law as I give it to you. If a lawyer says something different about the law, follow what I say. You must take all my instructions together as the law you are to follow. You should not pay attention to some instructions and ignore others. To sum it up, it is your job to decide what the facts of the case are, to apply the law as I give it to you, and in that way decide the case. Now, all three charges are the same for each defendant. People of the state of Michigan versus Paul Bellar. People of the state of Michigan versus Joseph Morrison. And people of the state of Michigan versus Pete Musico. Now, count one, gang membership, felonies. being an association or member of a gang, did commit or attempted to commit the felony of providing material support for acts of terrorism, and his association or membership in the gang provided the motive, means, or opportunity for committing the crime. Count 2, terrorist acts providing material support, did knowingly provide material support or resources to a terrorist or terrorist organization to be used in whole or in part to plan, prepare, carry out, facilitate, or avoid apprehension for committing an act of terrorism against the United States or its citizens, this state or its citizens, or a political subdivision or any other instrumentality of the state or local government. Count 3, weapons, felony firearm, did carry or have in his possession a firearm, to wit, a rifle at the time he committed or attempted to commit a felony, to wit, providing material support to a terrorist or terrorist organization. Now, what I'm going to do here in a moment is we're going to dismiss you for the day. But before you go, I want my bailiff to take you across the hall, show you where the jury room is. So tomorrow morning when you come in, you can, if you want to bring a cup of coffee or something like today, go ahead and do so. You can just gather there, and then once we've got everything set here, we'll go ahead and bring you in and we'll start with the testimony. Good night, and I'll see you tomorrow morning, 9 o'clock.